Start para. Rule made returnable forthwith by consent of the parties taken up for final disposal. This petition takes exception to the order passed by the Family Court Pune on 4th June 2014 rejecting the petitioner's application for waiver of the cooling off period provided under section 13B of the Hindu Marriage Act 1955. The petitioners got married on 18th July 2021 as per Hindu rituals in Pune. It is the petitioner's case that there were differences between them after a period of 1 year and hence they started residing separately on 10th October 2022. Though reconciliation attempts were made by their well-wishers, friends and families, they failed and ultimately they decided to seek a divorce by mutual consent. In terms of the amicable settlement between the parties, petitioner number 2 agreed to pay an amount of rupees 10 lakhs towards permanent alimony. Accordingly, petitioners filed a petition for dissolution of their marriage by mutual consent in the Family Court at Pune on 13th March 2024 and the same was registered on 20th March 2024. Since the parties had already been residing separately since 10th October 2022, they also filed an application for waiver of the 6 months period and requested for a decree for the dissolution of their marriage. The said application is rejected by the Family Court on 4th June 2024. Hence, this petition. Para. Learned counsel for the petitioners submitted that in spite of making attempts, parties were unable to reconcile their differences, so they decided to apply for dissolution of their marriage. He further submitted that it was impossible for the parties to reside together, hence they applied for a waiver of the statutory period. He further submitted that the learned judge of the Family Court has rejected the application on the ground that there was no case made out to exercise the discretion to waive the statutory period of 6 months. However, he submits that the learned judge has not given any reasons for rejecting the application. Para. Normally, we come across cases where parties continue to fight, though there is no possibility to reconciliation. In such cases, the parties are encouraged to explore the possibility of an amicable settlement and are even referred for mediation so that they can put an end to the litigation. However, when the parties apply for divorce by mutual consent, they have taken a conscious decision to separate and thus have shown a reasonable approach. Such a decision shows that they have decided to move ahead and thus there is every chance of rehabilitation. The newly married couple not being able to reside together or a couple married for quite some time is unable to continue to stay together for various reasons itself would be a mental agony. Thus, once the court is satisfied that the parties have taken a conscious decision to separate and move ahead and that there is no possibility of reconciliation, the court should adopt a realistic approach and exercise the discretion to waive the waiting period. Hence, it is the duty of the court to assist the parties by exercising the discretion to waive the cooling off period and free them from the stress of their application for divorce remaining pending. Para. In the present case, I have interacted with both the petitioners who are present before me today on making a specific query with regard to the possibility of reconciliation. Both the petitioners reiterated that they are unable to sort out their differences and have made a conscious decision to separate. They further submitted that, in spite of making several efforts, they were unable to reconcile their differences and would not be able to stay together. The petitioners further inform that they both are well settled in their independent professions and the pendency of the petition is causing mental agony. Hence, they request that the cooling off period be waived and an order for dissolution of their marriage be also passed by this court. Stop.